Okay, Mr. Merritt's not ready though. He was in the hallway. Which matter are you on?
I'm on Rodney Gill versus Andre Bates, Shanika Bates and Andre Smith.
And we're running
And,
that.
and everybody's there and it's consent.
Oh, it's a consent?
Yes, ma'am.
Okay. On the record, in the matter of Rodney Gill versus Andre Smith and Shanika Bates, file number is 24-02931 SP. Council, take your appearance.
Yes, Robert McCarthy, P28-450. I represent Rodney Gill, who's present in the back of the courtroom, as are Andre Smith and Shanika Bates. We've reached an agreement today and they've signed the consent. The balance due on this land contract as of today, together with costs, is $17,974.27. That is less than 50% of the purchase price has been paid, significantly less. The property is 1435 Roosevelt Avenue in Lansing, Michigan, and I'm asking that an order be issued that upon the expiration of 90 days, if the full amount hasn't been paid, that a judgment be issued granting my client possession of the premises. And both defendants have discussed this matter with me, and they have signed the proposed judgment.
Okay. And so what council has said is accurate?
Yes.
Okay, so you understand that in order to move forward in this fashion, there's certain rights that you have that you need to give up. And one is your right to be represented by an attorney. You were advised of your right to be represented by an attorney at your pretrial date. Did you want to give up that right?
Yes.
You also have the right to have a trial in this matter. We did not receive a demand for trial. Did you want to give up your right to trial in this?
Yes.
Okay, anybody threatening you to get you to give up those rights?
No.
Any promises being made to you to give up those rights?
No.
So you want consent judgment to enter today, where plaintiff has the right to possession. The amount due, including costs, was $17,974.24. This is less than 50% of the purchase price has been paid, and that an order of eviction may be issued upon expiration of 90 days if the amount in 3 is not paid. Correct?
Correct.
Okay, there's signatures here. Did you sign this, ma'am?
Yes.
You signed
Yes, I
this, sir?
did.
You have 3 business days from today's date. If once you leave here, you realize that you misunderstood any of the rights that you just waived, you can return to the court, request to have this judgment set aside. We'll set it for a hearing, and then you'll explain to the court how it was that you misunderstood your rights, okay?
Yeah.
Okay, any appeal date is as of August 5th, 2024. Do you have any questions for the court today?
No.
Any additional matters for the record, counsel?
No, Your Honor.
You're all set.
Have a good one.
Same to you. Okay, Mr. Nair, you're here on Naja Nona versus Jessica Coley.
Yes.
Okay, on the record in the matter of Naja Nona and Jessica Coley, file number 24-01962, counsel appearance.
Please court, Your Honor, Attorney Frank Narrett for the plaintiff landlord, and I'm filling in for the Whitty law offices in this case. Well,
For some reason, I don't see that file. Yeah, I don't see the final. Okay, and what's your name, ma'am?
Jessica Coley.
Okay. There's a date and the time that was set for hearing for non-payment of rent. Did you come to an agreement on this?
We did, Your Honor. We met, we've reviewed it, we've agreed on a consent judgment, if I could approach the bench.
Yes, please. Okay, that's how you want to proceed, ma'am, with the consent judgment?
Yes, ma'am.
Okay, so it says here that you want judgment to enter by consent where you agree that the amount to retain possession is owed in the amount of $5,500 plus cost of $215.84 for a total of $5,715.84. That you'll either pay that or vacate the property of 528 South Mifflin Avenue, City of Lansing by August 5th, 2024, correct?
Yes, ma'am.
Okay, it says you're also consenting to money judgment entered damages $5,274.20 plus cost $215.84 for a total money judgment $5,490.04, correct?
Those two different amounts.
There are two different amounts because one is the amount owed to keep possession and one is a money judgment amount.
Yes.
It's the money judgment is less than the amount for possession.
Oh, okay. Yes. Yes, ma'am.
Okay, you understand that?
Yes, ma'am.
Okay, and that's your signature here?
Yes, ma'am.
So you have certain rights that you need to give up if you want to move forward with this consent judgment versus your right to be represented by an attorney. You were advised of your right to be represented by an attorney at your pretrial. Did you want to give up your right to have an attorney with you today?
Yes, ma'am.
You also have the right to proceed to a trial and you could have demanded a jury trial. Do you want to waive your trial?
Yes, ma'am.
Anybody threatening you to do that?
No, ma'am.
Any promises being made to you in exchange for you entering into this agreement?
No, ma'am.
You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you waived, you can return to the court, request to have this set aside, and you'll explain how you misunderstood your rights, okay?
Yes, ma'am.
Do you have any questions?
No, ma'am.
You already got a copy?
Yes, ma'am.
You can get your copy with my signature on it if you want to wait just a moment. Any additional matters for the record?
Okay, thank you.
You're all set.
Thank you.
Thank you. You ready on Prosperity as well?
I am.
Okay, on the record in the matter of Prosperity LLC versus Matthew and Catherine Howell, file number 24-01963. Council appearance, please.
Please court, Your Honor, Attorney Frank Narrett for the plaintiff landlord. And I'm filling in for the Whitties today.
Veronica Pereira, P 79674, on behalf of defendant Catherine Howell.
Okay, today was the date and the time that was scheduled for a hearing, and there's a request to adjourn.
Yes, Your Honor, Mr. Nerat spoke with our office, and we've agreed to seek an adjournment of 30 days, please.
And what is the purpose of the adjournment?
Your Honor, there are some repairs that are being made to the unit, and the property is going to be re-inspected in about 30 days' time, so we'd like to give some time for that to be completed before we proceed.
August 28th at 1:30.
Thank you, Your Honor.
No problem. Do you have any questions for the court today? We're adjourning the hearing for 30 days, yes.
Before we have to do that.
No, before you have a hearing,
In the hearing in 30 days.
correct.
August 28th is the next. Yeah, and we can talk more about moving forward your options. But August 28th is the next court date that we have to be back.
Okay.
Any additional matters for the record?
Nothing for plaintiff, Your Honor, in this case.
No, thank you, Your Honor.
Thank you. You're all set.
Thanks.
Thank you.
Yeah, I can't find. Let's see. This is the Niger, Nona, and Foley. Am I? Anyway. Yeah. I don't see it in the hearing docket, but even when I went to, my stuff was stuck in prep earlier, I think, or something like that. It wasn't there either. Alright, what's going on? Oh, wait, I see it now. Okay, let's see. On the record in the matter of Stone Ridge Metals versus the Mecca of Chonu, file number 24-01822. Council appearance.
Good afternoon, Your Honor. Nicholas Garlinghouse, P number 72150 on behalf of plaintiff and a representative of my Stone Ridge Meadows, Wendy Martin, is here with me as well.
Okay, sir, what's your name?
I'm Matt Channel.
Okay, today was the continuation of the hearing. I think it was so I can get the proof of the property being tested for mold.
Correct, Your Honor. I submitted a copy of the report on my file, and I do have printed off copies for everyone if you'd like that as well.
Yes, please. Thank you.
You're welcome.
Okay, so can you explain what you produced?
Yes, Your Honor. This is the mold samples, or the samples taken from the apartment were sent in and tested in the lab. This mold test results were taken from samples in the bathroom, the cabinet that was in the pictures, and then the bottom of the air conditioning unit in the apartment. And then the results show low levels of one type of mold in each spot. The cladosporium in the bathroom and under the AC unit, and then habitability, I'm not pronouncing that correctly, in the cabinet next to the stove in the kitchen. There is an explanation of the types of mold and what they, oh, I'm sorry, it's 10 ASP. I was looking at the wrong, off by 19 BN/ASP, the type of mold that was detected in low levels in the kitchen cabinet. There are explanations of the different types of mold and what they, common areas or reasons for them growing, and what types of health issues they may cause, depending on the severity of exposure.
So you reviewed that, sir?
I did, but I do have some discrepancies about it.
You have discrepancies about what?
For one, when they came and tested it, they only brought 3 strips to test. So there was more areas in my home that had mold that did not get tested.
You said they only brought 3 strips to test. You said there was mold in the bathroom and kitchen cabinets, and wall and living room, what you shared to the board.
I thought I mentioned that there was some in my closet in my my bedroom. In the email that I sent you, the first email I sent you.
I don't read emails. That's not how judges get evidence. Do you get it on the record? Evidence, if you email, it doesn't even come to me because it'll be improper for you to email the judge.
When I had submitted the evidence the first time, the picture of in my closet with the mold in there was in there as well.
Again, you submit evidence in court, just like he handed me. That's how you submit it. So if you sent some evidence via email, it doesn't go to me.
Right.
Because it would be improper for anyone to just send the judge whatever they wanted the judge to look outside of open court.
Correct.
That's unfair. So in open court, we present evidence as we present testimony. So if you sent something, I've not seen it.
When I sent the original evidence in court, it was in the original pictures.
Okay. So you're saying that there was some mold in your in your closet?
Yes, that did not get tested. Also in there was different spots in the bathroom. They only tested the ceiling, and only one spot in the bathroom got tested.
Okay, I see there's 3 ID samples. Is there a reason why they only decided to test 3 places? It says bathroom ceiling was tested, cabinet, and then AC.
Right, which is in the wall in the, I believe in the living room, the AC unit.
Okay, what cabinet is this that was tested?
It's next to the stove. It was the one in the picture that was submitted.
Okay, why was only one area of the bathroom ceiling tested is my question.
I can't answer that, Your Honor. I'm not sure.
But you were present?
I was not.
Okay, so we don't know what portions was tested?
Nothing that I could testify to, Your Honor, other than that it was in the bathroom ceiling as indicated on the report.
Pictures for this case? Yeah. Let's see. Oh. What is this a picture of again?
That is my closet.
In the bedroom?
Yes.
Are you saying that area was not tested?
No, ma'am, it was not.
Okay, and it clearly shows a water stain or spot or something. Was there some leak there?
Yes. The area is not damp to the touch, but it looks as if there was some water getting into there.
Was it like that when you moved in?
No, ma'am, it wasn't.
Do you know how that got there, or are you aware of any leak?
I know at one point in time when I was having issues with my shower, the maintenance team went into that outline right there because that's where they go to fix my shower. And a time after they fixed it, that stain appeared within our roof.
Oh, okay, so the stain, the black portions and then the discoloration on the wall, that's something that controls your water. Is your bath sink and tub are behind this wall or something?
Sorry, just the shower.
The shower's behind that wall?
Yes, behind that wall.
Okay, and then what is this? This was by the tub?
Yes, that was exactly right next to the tub and that did not get tested either.
Is this the area you said was tested?
Yes, ma'am. That right on the ceiling itself, they didn't get the wall, but they got the ceiling itself.
Then they tested that,
They did test that, yes.
and this is what?
That is under the air conditioning unit and they did test that as well.
That's a cabinet again, correct, same cabinet?
Yes, ma'am.
Okay, so the concern for you is that they did not test this portion of the. Is that a hole right here?
It is. It's so much damage that there's a hole now.
Okay, any additional evidence?
I sent some more things in the email. Is the proper way to do it to send it now? There's a big, in my bathroom cabinet itself, there's a leak from the sink. That area-
Currently?
Yes, currently the area didn't get tested and the cabinet is almost falling apart. The wood is pulling away.
You showed them that?
No, ma'am, I did not show them that today.
You need to show them what evidence you're trying to show the court.
All
And
right,
you sent it where?
I sent it to the same email.
Take it forward.
Even with the pictures of my bathroom cabinet. I did at a time and I never got a response. I do not know approximately when I did.
Okay, and Mr. Galios, this is DIY mold test. This is a do-it-yourself mold test?
Yes,
I'm
ma'am.
asking Mr. Galios.
Your Honor, I believe the collection portion is, was conducted by the maintenance staff, and then it's processed in a lab in South Carolina.
Oh, so you all didn't have a specialist come to inspect and decide what to test?
We were unable to get anyone in time.
You sent it? Yeah. Well, as you're frozen. Great. Emails are slow. Okay, did you make a maintenance aware of this issue?
Yes, ma'am, I did.
When?
I do not know approximately when I made them aware of it.
How did you make them aware?
When I spoke with the property manager at a point in time, I mentioned these maintenance issues that I was having. He told me at the time that I can text her to set up a maintenance appointment. I have messages with the property manager, and I have her saying that she set up the maintenance, but nobody ever came.
When was that you have the messages from when?
I can get to the exact date of when those messages were. He spoke on March 25th of this year. I'm not sure what that is.
Excuse me?
I'm sorry, I was answering her question.
That's not how we answer questions in court. She doesn't get asked questions. Any other evidence?
No, ma'am, not that I have.
What about you, Mr. Brown?
No more evidence, Your Honor.
Make the argument.
Thank you, Your Honor. Since I believe the only issue that was still up for consideration is the mold issue, since we had discussed the rest during closing arguments, I would just reiterate that the amounts that we had presented in the original arguments were uncontested and still remain at $4,279.50 in back rent, court costs of $258.34, which is a total of $4,537.84. We did request a money judgment as well. Today is the last day of a billing month. Rent comes due on the 25th of each month, so there'd be no proration as of today's date. And really the question comes down to whether there should be an abatement of rent, and if so, how much. That would be based on the mold issue that we described, or that we were discussing. I would say, given the results coming back as low and being tested in the main problem areas, I would say that at least minimal abatement of rent would be if any abatement of rent, it should be minimal. And just the other habitability issues that we had discussed before, being either caused or contributed to by Mr. Opponent, we would just be dealing with whatever the court decides is corresponding to the mold issue.
Mr. Ochoni, you can make your argument.
Yes, I just feel like as if, see, I've been dealing with them for a long time. Multiple payments requests with them. I've never heard anything back. Every time that I come to them, they haven't done their part. And also as well too, these are not minimal issues. I've had it in almost every room of my apartment, and it's something that I've been dealing with them for a long time.
Why don't you move?
I was planning to, this proceeding started because I went to the property manager and I told her that I am planning to move and I need to get the rent situation and all these things figured out before I leave. We need to come to some agreement.
When are you planning to move?
I want to move as soon as possible. I was just waiting until this was done, but
As soon as
will move.
possible, so you can move tomorrow?
No, not as soon as, excuse me, not as soon as tomorrow, but I'm ready to move within the next 60 days.
Within the next 60 days?
I can move within the next 30 days.
If I rule in their favor, you only get 10 days. That's the law.
Okay,
And that was 10 days from whenever I made a ruling. So if I hadn't made the ruling at the last hearing, you would already been out.
right. I can move within 10 days.
Okay, I've heard evidence for at least 2 days on this matter, and I think I made it clear on the record before that I believe that some abatement was warranted, but that I don't believe that you get to live free based on what I've seen. I have some concerns, and I ordered them to have the property tested for mold, but at no time did I expect that it would be a DIY mold test conducted by your client's maintenance person who is already, the accusation is they're not fulfilling the maintenance request in the first place. And then they go in and they decide based on their own discretion, what they want to test and what they don't want to test. That's not gonna fly because it looks like the area, just looking at the pictures, that had the most deterioration from a substance that's black wasn't tested. But that was your maintenance person who decided what they would test and what they wouldn't test. And I don't know how a DIY test measures and whether or not, or what the error measure is, or how much you're supposed to swab before you submit it. I don't know that, because my expectation was that a specialist would come in and test for mold. And if there wasn't sufficient time to do that, then my expectation would be that your office would have said, Your Honor, we got a schedule and we need more time because they'll be in for a certain day. Not for us to makeshift a DIY mold test. He could have did his own DIY mold test. And for all I know, those results could have been different. I can't even put the person who tested these results in this seat right here and question about it because they're in North Carolina. I believe that there is an overwhelming amount of mold in this house. I recognize this says that the areas of 3 places that were tested show low. It gives some 4 rating scales of very low, low, medium, high, very high. But what I see based on my plain eye is a lot of mold. The whole tub is coming away from the wall because of a black substance. And why the maintenance or the property management didn't think that it was appropriate to go and fix the substance we're trying to evict him, it's beyond my understanding. Why, if he has outstanding maintenance requests, if we're gonna evict him, we're gonna get in there and get these fixed, you don't think? So that we don't have these issues in court. You want to show that you kept the property in working order. He should not live or have to pay market rent for a place that has mold in his kitchen, where he's got to keep his food in the cabinets, where he has to bathe or in his shower, in his bedroom, coming out of the closet wall. He's had issues with, I'm not concerned about a broken towel rack, should be fixed, but I'm not concerned about it because I don't even know why it got broken in the first place. He might have broken it, so he should be responsible. And then the burn that he referenced, I told him before that that's his error. He fixed the burn or have the maintenance fix it at his expense. But mold and living in a place where there's mold spores growing in the places where you sleep, eat, and bathe, I don't think either one of you would live under those conditions. I think you would want those conditions to be taken care of. And then having people enter your property. I understand that there's emergencies that warrant entering units in an apartment complex without notification prior, but something should have been left to let him know that someone entered his property, so that when he gets in, he knows while I was away, they entered my property. Treat people with respect if you're going to do the business of renting. And so I am going to abate 1/3 of his rent. I likely would have abated 50% of his rent, but I feel like he could have left If I'm not gonna live in a place with mold, and if it was so bad, then I think that you should have packed up your things because your lease has expired. You're month to month. There's nothing holding you there. You could have let them know, I'm leaving and these are the reasons why I'm moving out. And then that strengthens your claim that you were constructively evicted. But you chose to live there. You're not coming in here telling me that you're having any medical issues because of it, or that you had to go be hospitalized and you're wheezing. That's not what you're telling me, but I recognize that you shouldn't have to live with that. You don't have a cabinet that you can put your food in that doesn't have mold in it. That's disgusting. And no one should take a bath in a molded bathroom. And so nonetheless, I'm gonna abate a third of his past due rent, not the court costs. And that needs to be paid, or you need to vacate within the next 10 days. You gonna do the math for us, counsel?
I can do that. Your Honor, abating 1/3 would bring the total of outstanding rent from 4279.50 down to 2,824.47,
Plus the court costs, which are,
court costs are 258.34. That would be a total of $3,082.81.
they need to pay that or you need to vacate within 10 days. If you all want to negotiate the 10 days, that's between you. The 10 days is the court order under the statute. Do you have any questions for the court today?
I do, so it's a and or, like I pay that or leave within 10 days.
Well, for possession, you pay it or you vacate. However, they're seeking money judgment, which is coming next.
Your Honor, again, this is the last day of a monthly billing cycle, so there's no proration since rent comes due again tomorrow.
Okay,
So the amounts are the same. It would be the 2824.47 plus court costs of 258.34 for a total of 3,082.81.
okay, so money judgment will enter as well. So they have the right to get that money even if you move out, okay?
Sorry, what was the amount for the money judgment?
It's the same as the possession judgment, $3,082.81.
Correct, Your Honor.
And that's the past due rent amount that's been abated by 1/3, and then the 258.34 for court costs.
So even if I leave within the next 10 days, I still owe them that?
Yeah, you've had their property all this time.
Mhm.
So you still owe them that money. Do you have any other questions?
No, not at this time.
Okay, you have an order for me?
I do, Your Honor, may I approach?
Get you a copy of this order. Any additional matters for the record?
Nothing further from me, Your Honor.
You're all set.
Thank you, Your Honor. Have a good day.
Same to you. on the record in the matter of GCJ Group Inc. versus Philip Curtis and Brittany Horsley, file number 24-02472. Councilor Bears.
Catherine Gable, P 81555 on behalf of plaintiff,
Ma'am, what's your name?
Brittany Horsley.
Ms. Philip Curtis. How are we proceeding, Council?
Thanks, Your Honor. I was unaware that Ms. Horsley was here. I haven't had a chance to speak with her. Happy to do that.
Okay.
I can proceed on a default as to Mr. Curtis. I have that prepared, ready for entry, but
Okay, I'll take the default and then you can approach. Yes.
I'll just cross off her name on this.
Thank you. Welcome. Okay.
I'm gonna go August 5th.
Mr. Narrett, you have Sharon Kassane here.
Yeah, she was out in the hallway, Your Honor. We were unable to reach any kind of a resolution.
Okay, what about Andy Moat?
We've entered into a consent order for conditional dismissal. I've given the paperwork to your judicial assistant.
Okay, on the record in the matter of River Shell Lansing versus Andy Moten, file number 24-01966. Appearance for the record.
It's Court, Your Honor, Attorney Frank Narrett for the plaintiff landlord, filling in for the Woody Law offices today on this case file.
And sir, what's your name?
Andy Moulton.
Okay, Mr. Moten, today's the date set for a hearing on a eviction proceeding, and so I understand that you want a conditional dismissal, correct?
Yes.
Okay, so I have here a consent order for conditional dismissal. It states that you agree that you shall pay on or before August 5th the amount of past due rent, $5,662.52. That's for rent due and owing through July 30th, plus court costs of $165.91 for a total amount due of $5,828.41. Is that correct? And so you understand that you had certain rights that you will need to give up in order to have this matter dismissed upon the condition that you make that payment? You had certain rights. Your first right is to be represented by an attorney. You understood that you could be represented by an attorney today?
I understand it now.
Do you want to give up that right so that you can have a conditional dismissal?
Okay, I just wanted to ask, conditional dismissal, so.
It's dismissed today on the condition that you pay the amount you agreed to pay by the date you agreed to pay it,
Or move.
or you can move.
Okay, once I move, I don't have to pay it, right?
Correct.
Okay, yes,
That's what you understand that?
yes.
Okay, so back to your rights. You have the right to be represented by an attorney. You want to give up your right to be represented by an attorney?
Yes,
Do you also want to give up your right to have a trial on this matter?
Okay.
Anybody threatening you to give up those rights?
No.
Any promises being made to you if you give up those rights?
No.
You understand that partial performance won't satisfy this conditional dismissal, so that means you either have to pay that amount by August 5th or you have to vacate by August 5th fully. So vacating means you take all of your personal items and you clean the properties, room swept.
we already, yeah, I'll be out.
You don't leave no trash.
Right,
You
no,
turn over your keys,
yes,
all of that.
all of that.
Okay. You have 3 business days from today's date. If after you leave here, you realize you misunderstood the rights that you just waived, you can return to the court, let us know that you misunderstood your rights and you want this agreement set aside. We'll set it for a hearing, okay?
Okay.
We'll get you a copy of this. Any additional matters for the record?
Nothing further, Your Honor. I just want to confirm to Mr. Moulton that no money judgment was sought in the complaint. In this, there is no money judgment being entered today. It's a vacate.
Yes, thank you.
Thank you.
No problem.
Thank you.
No problem. And we need to have a hearing on the other one.
Yes,
She can come inside.
I invite her in.
Yes, please.
Right here. This one for you.
On the record in the matter of Magnolia Investments versus Sharon Kassane, file number 24-01965, counsel appearance.
Please court, Your Honor, Attorney Frank Narrett for the plaintiff landlord, and I'm filling in for the Whitty law offices on this case file this afternoon.
Ma'am, what's your name?
Sharon Kassane.
Okay, today's the date and the time set for a hearing for non-payment of rent. The parties met, were not able to come to resolution, so that to me means that you believe that you have a lawful right that you can withhold the rent and stay in the property, correct?
Sort of, yes.
There's no
a-
sort of, it's a
Okay.
yes or no.
Yes,
Okay.
I don't want to stay there.
Yeah, but you believe you have a lawful right where you don't owe them and you can keep the property and keep possession of the property. Correct?
So I say sort of, yeah. I mean, I know,
Yeah, I'll let you proceed.
Thank you, Your Honor. Please court, we met and I tried to get specifics from the defendant as to why, and she would not give me any specifics so that I could have my client go through her records. Number of requests for maintenance have been made. My client has responded promptly to them. As an offer of proof, we show rent to retain possession as of today's date of $4,065.19. Court costs of $218.84 for a total of $4,284.03. That has been prorated to today for the money judgment that was paid. Again, an offer of proof, damages of $39.1390, cost of $218.84 for a total of $4,132.74. I'm prepared to call my client's representative, Jennifer Holsworth, to the stand to put on proofs.
Well, are you disputing that's past due amount, ma'am?
plenty of it, I am, not all of it. I feel like there was money owed to me for a lot of the work that I'm still doing to the house as far as the cleaning and yard work.
I was trying to avoid it, but you can call her.
Please take that with you, your records. You may have occasion to read.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can have a seat, ma'am.
Holsworth,
I was gonna have her spell her first and last name.
Sorry, squished in here. Jennifer, Jennifer, Holsworth, Holzwarth.
Counsel, you can proceed.
Ms. Holsworth, are you employed by Magnolia Investments?
Yes,
Are you familiar with the rental property at 4201 Lowcraft Avenue here in Lansing, Michigan?
Yes.
And you have a tenant there named Sharon Kassane?
yes.
And have you been? How long has Ms. Kassane lived there?
She signed a lease in January and occupancy on the 23rd of February.
Of this year?
Correct.
Okay, and from time to time, has she made maintenance requests of you?
She did not make any maintenance requests until there, 4/4 was her first maintenance request.
April 4th?
Yep.
And what was that?
She had said that she unplugged well, there was numerous, but, let me find the email on 4/4. Request for repairs, provide a refrigerator and stove with oven, both replacement appliances need to be in good working order and clean. Okay, so start the email. I'm writing to ask for repairs at 4201 Lowcroft Avenue. Lowe's list of higher priorities that need attention as soon as possible. As you will notice, some of these issues are going to cause more damage to the property if not fixed soon. For one example, I just recently noticed water ending up on the floor in the cabinet below the kitchen sink. Another issue is just moved into a high priority zone that's not on the list. The door handle completely broke off this week on the front end of the storm door. See the pictures. There are issues negatively affecting my quality of life, like useless kitchen appliances and bathtub or shower. It's incredibly difficult to rely on a cooler to store my food and beverages and expensive to having to buy ice every day. I also continue to worry about other issues still that could further affect my overall health, physical, emotional, and mentally, like the ongoing bathroom issues, mold, leaky faucet, constant water dripping, rusted drain, etc. I have not even once taken a bath or showered or made conditions for the bathroom since I moved in. I have innovated the necessary deep cleaning here. I've focused on the kitchen and mainly the living area. You want me to read this whole thing?
No.
Okay.
So that was it.
Requests for repairs, which have all been addressed. She asked me.
I'm sorry, gotta wait for a question now.
Sorry, I'm sorry.
Okay. So that was in April,
Yes.
and she had moved in February.
Yes, she was given the keys. We did a walkthrough of the property on the 4th of February, on Sunday the 4th.
That's
And then-
this is this year, correct?
Correct, on this year, yeah, Sunday the 4th at 11:30 a.m. The only thing that she made mention of was the kitchen faucet was loose. And I said, well, give me a list. Her daughter couldn't stay. I gave her the
That's
keys
not-
early, almost 3 weeks early. I gave her the keys and said, make me a list. We'll fix whatever you need done. And I did not hear from her after numerous contact. I didn't even know if she was moving in until
That April email.
the April email request for.
Okay. And did, as far as any specific things she mentioned, did you or representatives of the landlord address those matters?
Yes. Yes, everything has been addressed. She did ask for the appliances to be replaced. She told me they were inefficient. And asked me to replace them. They were in working order when she moved in, and she moved them and mangled them, and they're out in the garage now.
Is there anything else that she specifically asked you to do with respect to the habitability of the property and the fitness for intended use that you did not take care of?
No.
Okay. I gave the judge some figures. Is it correct that currently rent to retain possession is $4,065.19?
Yes.
And according to your understanding, court costs $218.84.
The rent, actually, the ledger is 4,030.19, is that correct? You said 4,000, you said.
$4,065.19.
Oh,
Do we have that wrong?
I have, yes, I have 4,030.19.
$4,030.19.
Yep.
And did you authorize your attorneys to put this into litigation to
Yes,
seek payment?
yes,
And it was kept fit for the use intended?
yes,
And it was, are you in full compliance with all local, state, and municipal housing codes and regulations?
yep, I have my code compliance certificate right here, valid through 8/1/2025.
Very good. I don't have any other questions, Your Honor, this time.
Ma'am, do you have any questions for this witness?
I don't know how to effectively,
Well, let me know what you want to ask and I'll help you.
well, I've been trying to get mediation. I've been trying to work with Joe McDonald, Fort Portland, mayor's office to get, so we can get mediation. so I could actually have somebody help me talk with her.
Yeah, but we're in court now, so what do you want to ask?
I don't know how to do all that.
You don't know how to ask a question?
Well, there's a lot going on. There's stuff that started going on before, and frankly, I've never had anything like this happen to me before. I feel like I was put into a situation where she's not gonna fix it unless I ask her to fix it before I even moved in, and that's just some
Okay,
repair
well,
stuff. That's just some
what-
repair stuff.
So I'm gonna give you complete opportunity to tell your side, but right now, while she's sitting here, I just want to know if you have any questions of her. Otherwise, I'm gonna let her sit back down there.
I guess, one of the questions I'd like to know is what was all the pressure before I even moved in there? Why you gave me the keys early when I did not ask for them? Why you were pressuring me to put things to get the power turned on? But I didn't even move in until March 1st.
Okay, so the first
I mean,
question, because that's multiple questions, so we gotta break it down.
Yeah, that's what I'm saying.
You said that you felt pressure to move in.
In the first place, I mean, I ideally didn't even want to move in until April 1st.
Did you sign a lease?
I did. And again, there was pressure doing that too.
Did she sign a lease?
Yes.
There was
Okay,
tons of
what-
pressure doing
When
that
she
too.
signed the lease, what was the date that she was to move in on that lease?
She told me specifically she wanted to move in on the 23rd, and I
I
have
did
an
not say
email.
that.
and
23rd of
text
what?
message that-
Of what month?
February.
Okay,
That's not how
Okay.
it went.
well, you can dispute it, but not while she's testifying, okay? Any other
Okay.
questions for her?
Like I said, I don't know.
No
how to
questions
frame it.
about the conditions of, that you're alleging, or that you're going to allege, and
Well, just that I walked into a whole bunch of stuff that there's no way I could have known it until I got there, which I also said to her.
okay, I'm gonna remove, your excuse from the stand then, ma'am. Your
Okay.
excuse, you can go sit next to your attorney. You have any other witnesses?
No.
Okay, so you want to give testimony. I'm gonna have you raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes,
Thank you. Okay, why is it that you believe that you don't owe the rent past due $4,030.19?
I'm happy to pay what is owing, but I have spent countless hours, absolutely countless hours, and so has a friend of mine, with cleaning alone, just cleaning alone.
Cleaning the unit?
I don't think it ever has been cleaned. And
So you moved in on February 4th?
No,
When
no,
did
we
you
were
move
there together, maybe less than 30
What
minutes.
day did you move in?
I moved in on March 1st.
Okay, and prior to moving in, did you do a walkthrough?
I have been to the house, yes, but
Prior to moving in, you did a walkthrough, is it yes or no?
yes,
And was the unit dirty?
yes,
Did you tell them that I'm not moving in until it's clean?
not at that time.
Maybe not at that time.
Because I was overwhelmed trying to figure out how I need to get out of the place where I was at. For one thing.
Did you hear my question? Did you tell them that you want the unit clean before you moved in?
I don't remember when I told her exactly.
When or if,
When.
but you believe you did?
I believe that I said a lot of things.
I didn't ask you that.
Yeah.
You specifically.
About the clean, yes.
Did you request that the property be cleaned before you moved in?
Yes.
Okay, what was it that was dirty? Explain to me what was needed to be cleaned.
Deep clean, like it, thick. I've got pictures, well over 200 pictures, of the furnace.
The
Thick.
furnace?
Yeah, it's like it's an odd furnace. It sits in the middle of the living room. It's on the wall. So it's got a lot of like great like GRAT coverings, the coverings for it. A slotted
Okay,
where you can see, like
Okay.
a few different, I don't know what you call all that stuff.
What needs to
I'm
be
really,
cleaned?
pardon me?
what needed to be cleaned?
Well, that I didn't. This is what I was having a hard time with all the cleaning stuff, is that I was blown away at
What needed to be cleaned?
the cabinet, all the cabinets in the kitchen, all
The
the
cabinets were
walls.
dirty?
Yep,
What was dirty?
filthy, nasty dirty.
Like food was in it or
Oh,
what?
yeah, food, thick, gunky stuff. I don't even know how, I don't even know how.
What else
to
was
describe
dirty?
it. The floors,
Floors? needed to be mopped?
More than that. I mean, it was, the mold in several different places, but,
There was mold in
it
this,
was thick stuff. It was like stuff that,
mold when you moved in,
yes,
and you still moved in?
reluctantly I did, yes.
Okay, you have pictures of these conditions?
I have, yes,
Where are they?
on my phone.
How am I supposed to see them?
I know, I don't have any equipment to do all that stuff. I can't afford to have all that stuff done.
You
And turn it
don't,
up
can't afford to have what?
to have, I don't know, to get a service to it. I don't know how to get it off my phone to have it to show you, other than just to show you my phone. I am not set up to do, like, I don't have a PC, I don't have a computer.
Did you show Mr. Neer the pictures?
I sent her a lot of pictures, but
No,
I
no.
had more even.
The attorney, did you show the attorney the pictures?
I just met him today.
Yeah, and he said he tried to talk to you about the issues and he couldn't get the issues from you. So did you show him the pictures?
No.
Why not?
This just never came up.
They just did when he asked you to show him the pictures or show him what was the issue so that he can talk to his client to see if they can get it fixed.
I wasn't understanding it that way.
What was you not understand?
I was having a hard time understanding anything at this point.
I can understand your concern because I'm having a hard time understanding right now.
And I'm sorry about that. This has just been building up for so long and I don't have it straight. I have a lot of notes and I have, you know, what paperwork I do have. I have.
So you
plenty of
moved
stuff.
in, it was dirty, you said you wanted it to be clean, they didn't clean, you still moved in. Then what happened?
I did it because I didn't have anywhere else to go.
I get it. You moved in and then what happened? What is the
I was
reason?
learning a lot of the stuff as I went along with it though too,
But you did a walkthrough.
but it wasn't a thorough walkthrough.
But whose fault was that? So you moved in and only issue I've heard so far is that the cabinets were dirty, the floor was dirty. Did you
It
clean
was the
it?
pressure that I felt on things that weren't squared away before we even.
What pressure?
Before I even got there, when I would to sign the lease in the very first place, to even sign.
They
the
pressured
lease.
you to sign the lease?
Yes.
They put a gun to your head?
No.
They put
it
a knife
wasn't
to your
that
neck?
kind of no,
They told you if you didn't sign
it
it,
wasn't like
they
that.
tell you that if you didn't do it, they would do something to you. They threaten you to sign it. Ma'am,
No, but I felt threatened for a few different reasons.
what was those reasons?
It started out, the circumstances, it was a combination of things. I made up my mind that I was going to get out of the place where I was at, for one. So I had a determination and I had some pressure from my daughter because she was getting upset that I was still there. and
No,
she
what's the
wanted me to go.
threats from this?
So her friend had a lease on this place. It was a friend of
Whose
my
friend?
daughter.
Your daughter's friend had a
That's how I
lease.
got hooked up to the place.
So you
And I
took
reluctantly-
over a lease for your daughter's friend?
Well, I didn't take over his lease. I
No.
tried to get a different one.
Yeah, but, so you're saying this was a place that was leased by your daughter's friend?
Yes,
And he was moving out of the unit
right, and.
and you were moving in?
Well, but conditionally.
Answer my question. You were moving in? To the unit that he's moving out of?
Yes.
And the pressure was from your daughter?
Not like, no. I'm trying to explain this.
Well, you haven't told me how, remember what your name,
Jennifer.
Houseworth, how Miss Houseworth, I like formalities, how Miss Houseworth pressured you. How did she pressure you to sign the lease?
If I could go back and I'd have,
Do you have the proof of how she pressured you in your phone, is what you're saying?
yes,
Okay,
between,
you can look at your phone and tell me how she pressured you that you better sign this lease.
well, it wasn't like that. It wasn't like, she didn't threaten me to sign it.
What did she threaten, how did she
There were
pressure you?
things in, there were things that came up all along the way and they seemed individually the things that were happening and how I'm trying to, this is what I'm having trouble with and this is why I needed help. This is exactly what I needed help with, is to keep my thoughts straight, to get it all so where I could explain it, even to her. Because it wasn't getting through.
It's not getting through here either.
I
man.
know, I can tell, and that's what's making me really nervous and that.
You don't need to be nervous. I told you you can pull out your phone if you could read
Okay,
how she
well,
pressured you.
I can try.
Your phone's not up there, ma'am.
Yeah, I'm trying to, I know I have it, I'm sorry. And as it started in the first place, it was just the amount of communication that was happening before I even signed the lease. And, you know, I had my first contact with her on January 6th.
I don't want to hear about January 6th because you weren't living there. I want to know how
Right, but
you
that
were,
is how
I
long,
want to know how you signed this lease under duress.
But
Because that's
that's-
what, when you tell me that you were pressured, that you're telling me there was some
I-
duress. And I want to know how they caused the duress to make you move into this unit that was unfit to the extent that you have not paid rent and now you owe $4,030 and you don't believe you have to pay it.
when it gets put that way though, it minimizes what was going on.
Simon, that's exactly why we're here. We're only here because they say you didn't pay rent. And if you're
I-
disputing it, it's because you believe you have a lawful reason to withhold the rent.
And I'm not a lawyer.
You don't have to be a lawyer. We have people in here all day that are not lawyers. He just handled another case for Mr. Whitty where there was a conditional dismissal. He found, apparently upon that agreement, they felt like it was worth them dismissing and letting the person leave. You wouldn't even talk to him. I'm trying to ask you some questions because I have no clue what you believe your lawful defense is.
Okay, I did try to talk to him.
Okay, but now you're talking to me. So I want to know what your lawful defense
If I-
to holding the rent is.
I didn't know at what point, because first of all, I wanted to be compensated for the hours that I put in and that I'm still putting in to even have that place where I consider habitable and to have a yard, which is a huge responsibility when I'm renting a house.
To have a yard?
Well, to take care of it because it wasn't because of all the damage that was done, and there's no way I could have known that when there was snow on the ground and when it was still like it was, like I hadn't been there.
But you
I
know,
was looking forward to
what's
it.
going on inside the unit? Because you live inside. What is making the inside of that house uninhabitable?
Right now, it's what has been for the longest time are the appliances that I did not destroy those appliances. They were unplugged and the door was taken off the refrigerator and it was moved out into the garage. I didn't take it off the premises because it was bad. The refrigerator is completely all broken apart. And yes, because
it was broken up,
old and the seals are
ma'am,
bad on it, everything.
Ma'am,
Yes,
what does broken apart mean?
broken apart.
Broken apart?
Yes, ma'am.
When you moved in, it was broken?
When I got a closer look at it and took pictures of it, yes.
Where's the pictures of it being broken when you moved in?
It was just upon closer look. I mean, there was a
Just
lot.
show me the pictures.
Okay, I got. May I?
Wait, Brittany, can you get her phone for me, please?
Just trying to think of where to start there. I got them.
There's nothing on this phone that's gonna shock my conscience, correct? Like no personal things that I don't wanna see?
It's in a file. It just says Lowcroft. Yeah, it's just,
Thank you. Okay, so this is all the unit, is what you're saying?
yes.
What is this, ma'am? I don't know what this is.
Oh, that's that was the hot water heater.
Is this the medicine cabinet that you're showing a picture of?
Yep, she's replaced that. And the water heater was cleaned out. Those two things were done after I was there, yep.
Is this under a stove that you're showing me? Is that what this is?
There's a stove. There's pictures of the stove. Yep, stove and the oven.
Okay, so this is the.
And that made me nervous.
This is the refrigerator that you're showing me when you move in. It's not broken apart.
The seals. And there's broken pieces on it and just, I don't, my
Okay.
phone doesn't take that great a picture.
This is a great picture. I'm
Okay.
looking, you're saying this bottom where this is
That's just part of it. That's part of it.
is coming apart, which can be replaced for minimal. But so that was your concern?
That was part of it. There was black mold on the side of it. I don't know if I got any pictures of that because that hadn't been moved out when I personally took those pictures. My girlfriend moved it out for me.
I don't know if I see black mold.
No, there aren't in those pictures. There- you
Okay, yeah, I
can't.
don't see any black
No,
mold
there's-
on these
There's some on the
pictures,
wall, there was some on the wall. I
but I'm
think we got-
sure that this is a refrigerator, so it's moisture there.
I'm just really allergic to it, and so yeah.
Yeah, but that's a refrigerator, so what you wanna do is clean the refrigerator.
The
before you use
refrigerator
it.
was cleaned out, I mean, it ironically, or what, coincidentally, that was one of the things that it was actually cleaned out inside of it. It was probably the least dirty thing
What are
of
the
all.
pictures
but
of the
it was just-
outside of the house for? What is that supposed to show
Oh,
me?
there was just all sorts of things. That's just.
Okay, I don't really see anything outside the house. I mean, it looked like it could be power washed, but,
Right, but that's.
or maybe the shingles could be painted, but
I,
that doesn't affect the habitability of a home. Nothing in those pictures show me where you should
well, if I could get. 'em-
withhold $1 of their rent. So do you have any other evidence?
I tried talking and I filed a complaint to get some assistance and to get mediation so I could find a way to deal with a lot of this stuff with her
You filed a
all along the way.
complaint with the ombudsman?
Yes, and this is just the original contact that I had with them, and it took him several weeks before I got a response from him. This is the only thing I had in
When
print.
did you file your complaint with the housing ombudsman?
I asked for assistance to.
I know
for-
when.
I did this May 3rd. I
And-
finally ended up doing that May 3rd. I couldn't get through to anybody on the phone
And
and I
when
saw
did
a thing online.
And when
so-
did you get a response?
I would have to look in my email when I was checking kind of actively for a long time and didn't get a response. Then he did. It was a long time afterwards. I'm looking right now to see when I first got a response. I've only got my phone to work off of, so it's so I'm gonna have to search it because it only holds so much in here at a time. I apologize for that. I apologize for a lot of this stuff. I'm not set up, so I need some help.
No, you're really set up. You have a iPhone. I mean,
Well, but I don't have like anything else to work off of but this. That's it.
I mean, you really don't need anything else but an iPhone. You can do everything on an iPhone. You have
I'm
pictures.
old and
The
it's
cut
hard for me to.
I'm gonna cut to the
organized.
chase. The issue, ma'am, is not the resources that you have for electronics. The issue is that you don't have a claim to hold their rent over. You moved into this property. I've given you a chance and now we're done. You moved into this property. You did a walkthrough with the landlord or the maid. Cut me off one more time and I won't even explain my ruling. You did a walkthrough with the maintenance or the landlord prior to moving in. You've not been able to produce or provide the court with any explanation as to your statements about pressure to sign in the lease and move into this unit. To the contrary, what you shared lends me to believe that the pressure that you got was from your daughter and her friend because he was probably moving out and she wanted you to take over his lease and you did. And so the dirt that you're seeing from the cabinets is his. And so I would tend to agree that when you move into a new unit that, yeah, probably it should be cleaned, but that's usually when you have a fresh lease and not when you're taking over someone else's that is in a familial relationship with you. When I say familial relationship, meaning your family member or they're a friend of your family member. I don't know if that's the case because they didn't give testimony about that. You brought that up and that's just what I'm gleaning from what I can actually glean from what you've shared. You've stated that you've had issues with habitability, but I'm looking at the pictures of the fridge. Is the fridge brand new? No. Do I believe the fridge was broken? No. I see the door there. I don't see anything off the hinges. I don't see anything that will allow me to believe that that fridge could not have been disinfected and house your food safely. You told me that they came and cleared out the stove and they came and cleared out the heater issue.
I didn't say that about the stove, Caesar. I'm sorry. No, I hadn't got to that part yet.
I actually was just under the stove. And
Okay, I'm sorry.
And you said, yeah. But you told me they fixed whatever the issue was in the medicine cabinet. Under the stove, it does appear to be an older stove. Looks like it could have been cleaned out. and you could move on. You told me that you requested to have it cleaned before you moved in, but then you moved in without it being cleaned. And so once you did that, you kind of waived that. You don't get to stay in people's property
Your Honor.
for months after that and not pay their rent unless you have a lawful reason whereby you believe that whatever's going on in the property constructively evicted you from that unit. And you've not given me a
I
single
wanted to say
thing.
something about the stove if I could though, that
Oh,
when I
no,
turned on the
we've had
buttons to see if
judgment
it
in
worked.
favor of the plaintiff in the amount of $4,030.19 for pass-through rent plus court costs, $218.84. Do you have a judgment?
I do, Your Honor.
Thank you. And then you need to pay the full amount, $4,249.03, or vacate the property at 4201 Lowcroft Ave, City of Lansing, by August 5th, 2024. Money judgment will also enter at this time in the amount of damages, $3,878.90, which is past due money owed for rent, plus $218.84 for court costs, for a total of $4,097.74. You have until August 5th to file any appeal of this, or again, pay or vacate the property by that time. Do you have any questions for the court? Get your copy of this judgment. Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you very kindly.
Thank you. You're all set.
So I'm waiting for that, or is that gonna get me out?
We're gonna give you a copy. You can have a seat back there. Mr. Klug.
Judge, how you doing?
I'm hanging in there. How about yourself?
I do have one consent, and she said she just put not that much money in the meter, so.
On the record in the matter of Leroy Fro Apartments versus Mecca Barnes, file number is 24-01975.
That one, Dr. Barnes, got spoke with their attorney. We're going to adjourn that for 6 weeks, if that's possible.
6 weeks. September 11th, at what time? At 1:30. On the record in the matter of SK Limited versus Amani Littlejohn, file number 24-03534, counsel appearance.
Good afternoon, Your Honor. Jeff Klug appearing on behalf of Plaintiff SK Limited Dividend Housing.
Is Amani Littlejohn present? Counsel, how do you want to proceed?
Here, at this time, we'd like to proceed with a default judgment for possession only.
Default should enter.
Thank you. May I approach?
Yes. Okay, so you must have someone here for 315.
Yes, that's four.
On the record in the matter of Victor Stelmashenko versus Tyler Hall and Hannah Marcus. Although, ma'am, state your name for the record. State your, yes, which we just substituted you in for Mr. Stelmashenko. Anybody here for Tyler Hall or Hannah Marcus? Okay, they're not here. You want a default judgment?
Talk about it, we want to partial dismissal, but I said, I think to come over, but I don't know.
So then you can get a default and then get a writ in 10 days and kick them out. Is that what you want?
I also want a money judgment.
Well, we can put that on for a hearing, okay?
Yeah.
We'll get you default paperwork today and she'll assist you with that, okay? You can have a seat. Thank you. Who did you say was here?
It is Miss Naisha Foy.
Okay, on the record in the matter of Leroy versus Naisha Foy, file number 24-01978, counsel appearance.
Good afternoon, Jeff Klug appearing on behalf of Plaintiff Leroy Fro Apartments.
And what's your name? Naisha Boyd. Okay, Ms. Boyd, today's the date that was set for hearing for non-payment of rent. Council, how we proceed?
Your Honor, we reached a consent order for conditional dismissal. She has agencies paying everything minus the court costs. So she agreed to pay the court costs, $25 a month, by the 10th of each month until it's paid.
That's how you want to proceed, ma'am?
Yes.
Council, you can.
Judge.
Okay, so before you can have a conditional dismissal, I need to understand that you know your rights and that you're willing to waive them. So one of your rights is to be represented by an attorney at today's hearing. You understand that? Is that a yes?
Yes.
You want to give up your right to be represented by an attorney?
Yes, they didn't offer me one.
We probably were not eligible. You were at the pre-trial, which we did via Zoom,
Yeah,
and we told you about that right, and then you had legal services.
yeah, I think they did email me and say that I wasn't eligible.
Okay,
for
right, so
one.
then you would have to hire an attorney otherwise.
Oh.
Yeah, this is not criminal. You don't get a right to a court-appointed counsel.
Oh, okay,
Oh.
see, I didn't.
Yes, yes.
I'm
So
not
did you want to
sure.
waive your right to counsel to get a conditional dismissal?
Yeah.
Okay,
they
yeah.
said they didn't miss it.
Dismiss it, that's what I see, yeah. So do you also have the right to proceed to a trial? You could have demanded a jury trial. Did you want to waive your right to trial today?
Yeah,
Anybody threaten you to give up these rights?
no,
Okay, so you are agreeing to pay, and it says DHHS will be paying the past due amount of rent that's owed through the end of July, but you're going to pay court costs, $177.04. And that you will make payments of $25 each month by the 10th of each month until paid in full. And that your first payment will be August 10th, correct?
August 10th for 2024.
2024, correct.
Yes.
Okay, and so you understand that partial performance won't satisfy this. You have to make those payments. Because if you don't, even if DHHS pay their portion, but you're not following your portion, they can still evict you. You understand that?
Yes, they explained that to me out there.
Okay. I'm gonna sign and date that for today. You have 3 business days, and once you leave here, you realize, you know what, I don't think I liked this, and I misunderstood the rights that I gave up. I wanna hire an attorney, or I wanna have a trial. You can come back to the court, explain how you misunderstood your rights, and we can set that for a hearing. Okay?
Okay.
Any questions?
No.
We'll get you a copy of the paperwork. Any
Thank you.
additional matters for the record, counsel? Thank you. Yeah.
I got the Waterville Apartments and Miss Andrews. Same duo.
Oh, okay. On the record in the matter of Barterville versus Shanita Andrews, file number 24-03333, council appearance.
Yes, good afternoon, Your Honor. Earl Bach here for plaintiff, Barterville Apartments LLC.
Okay, and today's the date and time that's set for a hearing for non-payment of rent. How we proceed?
Yes, Your Honor, me and Miss Andrews have spoken also with the property manager in a breakout, or not a breakout room, but conference room down the hall. We agreed to entry of a consent order for conditional dismissal. It's a fairly aggressive plan, so it shouldn't take too long. Currently, the rent due is owing $4,175. That is due by this year. There's $241.05 in costs for a total amount of $4,416.05. We've agreed. Miss Andrews says she has some money now. She's going to pay $1,200 by tomorrow, 7/27/24. And then she's going to pay $1,000 twice a month on the 10th and $1,000 again on the 25th of each month, starting August 10th of 2024. Payments are going to be allocated to the currently accruing forward rent first, and then the above past due rent balance second. And this plan will continue until her balance reaches 0. At that time, case will stay dismissed, and we all move forward and be happy. May I approach?
Yes, please. And ma'am, that's how you want to proceed with a conditional dismissal? Okay, so I have here again that you agree to have the case dismissed today upon the condition that you'll pay past due rent on an amount of $4,175. There's court costs, $241.05 for a total of $4,416.05. That's for rent due and owing through the end of July. It says further conditions are that the tenant shall pay $1,200 by July 27th, and that the tenant shall pay $1,000 on the 10th. I'm assuming of August, and $1,000 on the 25th of each month, starting August 10th, 2024. Payments shall be allocated to currently accruing forward rent first and the above past due balance second. I'm not sure what that says, to continue until rent, oh, payments to continue until rent is paid in current. That's complete and accurate as to how you're gonna proceed. And you understand that you can pay that or you can vacate by,
But we'd have to wait till she missed a payment and then come in here.
correct. Well, it's a conditional dismissal, so.
We can file.
This is for non-payment possession.
Yes,
So then she does have the right to vacate. So that's what I was trying to figure out what the vacate date. She can pay or vacate.
that would be the judgment. But when we.
She can do it with a conditional dismissal too.
Oh, never. I do it just that.
So you don't want her to have the vacate options where you're saying. You want her to just have this payment arrangement.
Yes, she says she wants to stay.
Okay, all right, so then we won't address the line blank there. Okay, so you partial performance will not satisfy this agreement. So you need to follow this section to the T. Otherwise, they can request a writ to execute to get you out of the property. You understand that?
Yes, ma'am.
You have 3 business days. If once you leave here, you realize that you misunderstood your rights that I'm going to go over with you. One of them is your right to be represented by an attorney. You were advised of that right at the time of your pretrial when we did the video, but you want to waive your right to have an attorney represent you. You also have the right to demand a trial. You could have demanded a jury trial. You want to waive your trial rights in this matter. Again, if you misunderstood those rights, you can come back within 3 days from today, request to have this set aside and explain how you misunderstood your rights, okay? We'll get you a copy of this agreement in just a moment. Do you have any questions for the court? Any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you, you're all set. Must include must go in with the other person. So you have more, didn't you? I think you did. Okay, on the record, back on the record in the matter of GCJ Group versus Philip Curtis and Brittany Horsley.
Thank you, Your Honor. Captain Gable, the plaintiff.
When we have Brittany Horsley present in court, Philip Curtis has failed to appear. Default judgment will enter against him for failure to appear. Following proceeding.
Your Honor, we were able to reach a conditional dismissal with Ms. Horsley. I did email the court a copy of that because I had typed in conditions, so that it was legible. But essentially, we have agreed that the total amount owed is $7,548.99, and that's through July 24th, 2024. The defendant agrees that she owes that money to the plaintiff and agrees that if she doesn't pay the balance in full to plaintiff on or before August 5, she must vacate the property. However, if defendant does pay plaintiff a total of $1,200 by Friday, July 26th, but fails to pay the entire balance when due, she will have until August 9th at 5 PM to vacate. Action may proceed without further notice to defendant under 4B. Defendant may be liable for money damages if additional rent is owed or if there's damage to the property. And 7 is partial payment will not prevent any issue of or order of eviction. But I did add the words, but any judgment will be credited. Any monies received will be credited towards the money judgment if such judgment shall enter. That what we read on? I know that was fast.
That's how you want to proceed, Ms. Horsley? Okay, I have a consent order for conditional dismissal. Again, it says that you agree to pay past due rent in the amount of $7,241.77. That's for rent due and owing through July 24th, 2024. Court costs $307.22. That includes a filing fee, service fee, and attorney fee. And then for a total amount due of $7,548.99. You agree that you owe that amount to the plaintiff and agree that if you do not pay the balance in full or before August 5th, that you must vacate the property. However, if the defendant pays plaintiff a total of $1,200 by Friday, July 26th, but fails to pay the entire balance due, she will have until August 9th at 5 PM to vacate, correct? Okay, you understand that partial performance doesn't satisfy this. You gotta comply completely with this. You can't do one portion and not the other. You understand that? You have a couple of rights that you need to understand before you could look in your approach so you could sign. Before you can enter into this agreement, first is your right to be represented by an attorney today. You understood that, right? You want to give up that right? You have to speak so that the record hears you. Okay, you also have the right to have a trial. You could have demanded a jury trial. Did you want to waive your trial?
Yes, ma'am.
Anybody threatening you to do that?
No, ma'am.
Who signed? Your Honor, just for the record, she signed for defendant's attorney. She'll sign. I'll just cross out the word attorney and ask you to date it. Okay. And approach.
Yes. Okay, ma'am, you have 3 business days from today. If once you leave here, you realize that you misunderstood any of the rights that you just waived, you can return to the court, request to have this matter set aside, okay?
Yes, ma'am.
Oh, and that's for the other defendant on that. Okay, I will get you a copy of your conditional dismissal and the additional matters for the record.
No, Your Honor, thanks.
Do you have any questions?
No, ma'am. Thank you. Have a good day.
Same to you. You ready? Okay, on the record in the matter of Roy versus, actually, okay, Jamila Brown and James Hudson, file number 24-01976, council appearance.
Good afternoon, Jeff Booth, appearing on behalf of Plaintiff Lawrence Apartments.
And Alyssa Hall, Legal Services of South Central Michigan, on behalf of defendants, Ms. Brown and Mr. Hudson.
Okay, same date set for hearing for non-punitive rent, how are we proceeding?
Defendants requested a short adjournment of 3 weeks. I can try and submit applications with
HRCS, and she reports that she's contacted SCR for an application. Plaintiff has agreed to a brief adjournment.
requesting minimum of 3 weeks, whatever is after that, close to that earliest.
August 14th at 1:30. Any additional matters for the record?
No, Your Honor. I know that, not this matter, Your Honor, but we had a notice to appear for the Barnes. Should we get a copy for that one?
Brittany would have it. I'd imagine. It's printed already. Anybody here for Donald Roberts? I know you're here. You're here for Elena Watkins.
Yes.
I'm looking for someone here for Donald Roberts, but I don't think he's here. So you want to default? Oh, wait, Mr. Robertson is a letter. I think I read it earlier. And sent a email to the court at 12:46 stating that he was in a motorcycle accident. Or motor vehicle accident, that is, where he was a passenger. He walked away unscathed, but something about the seatbelt, so he's at the hospital now. Well, I'm just reading, ma'am, I'm just reading this on the record since it's been sent to the court. It doesn't sound like he's conceding, or he's contesting. It says the landlord tenant case against me is due to me owing the landlord rent. She is within her right to proceed in this fashion. I have no objections to that whatsoever. He says he doesn't dispute the amount. You want default judgment? Do you have it prepared already? Have you prepared your default already, or do you need us to print you one? We can print you.